Good afternoon, everybody. It's a great honour to be joining so many people who've contributed to celebrating whistleblowers who've bravely spoken out to protect the public. I'm joined today by a panel of outstanding professionals, and we're going to spend the next 30 minutes or so discussing some of the issues that I believe are most important at this time. Now, before I start, I better introduce myself. For those of you who haven't met me before, my name's Georgina Halford-Hall. I'm the Chief Executive of Whistleblowers UK, and I myself am a whistleblower, but that's the only time I'm going to mention that this afternoon. And in 2014, I helped to set up Whistleblowers UK. I'm a founding member with 4 key objectives. One was to campaign for an independent office of the whistleblower, to transform the way that everybody thinks about whistleblowers and whistleblowing. And the second was to provide practical, accessible and affordable assistance to all whistleblowers. And to help organisations to understand and recognise the value of whistleblowers and whistleblowing as the first line of defence against crime, corruption and cover-up. And lastly, to help educate the public, to demonstrate much more positive public messaging and signposting to where people can find help and support when they are thinking about or have whistleblown. But I think more important than me today are our wonderful panel. And I'm going to start by introducing Mary Robinson. Good afternoon, Mary. Mary Robinson is the MP for Cheadle, and she is also a trained accountant, and she's got a law degree. But most importantly, and why I know her so well, is because she is the chair of the all-party parliamentary group for whistleblowing, and she is leading the charge for reform in the UK of whistleblowing legislation. Now I'm going to move on to the only gentleman on our panel this afternoon, to Anthony Stansfeld, who's had a long and distinguished career, both in industry and in the military. And what Anthony's done is, well, it's just amazing. But he's been involved in the Army Air Corps, he's been involved in keeping the peace in the Far East. And then having retired from that, he got himself into politics, recently retiring from the esteemed post of the Police and Crime Commissioner for Thames Valley Police, where he really did lead the support for all whistleblowers exposing particularly financial crime. I'm sure he's going to tell us a lot about that. And recently he's joined Whistleblowers UK as one of our amazing team of directors. So thank you for joining us, Anthony. I'm going to move on now to Lindsay Rogerson, who's a great honour to be working with this afternoon. And she is an editor covering financial regulation at Thomson Reuters. She has consulted on the impact of financial regulation across a number of private sector organisations, and she's also an expert in regulating in the interest of consumers, having served 6 years as a member of the UK's Financial Services Authority's Consumer Panel. She's worked in this area across Europe, and she continues to be a member of the UK's Council for Consumers Forum and has acted as an advisor to charities, including Age UK. Lindsay, I have to say, is an award-winning investment writer, and she's edited a number of investment publications, as well as the financial section of Scotland's national newspaper, The Scotsman. Welcome, Lindsay. And last but not least, this afternoon on our esteemed panel is Alexandra Sidosis, who is one of our leading stars on the Whistleblowers UK's legal panel, but she is also, most importantly, a barrister specialising in employment law here in the UK, but she is also qualified on the US bar. So I'm sure that some of you probably recognise her watching this. Welcome, everybody. And I'm going to start by asking a question to Mary. Here we go. So let's start by looking at our current legislative infrastructure. The research conducted by the APPG has concluded that the Public Interest Disclosure Act fails to support healthy whistleblowing cultures. Now, Mary, as the chair of the All-Party Parliamentary Group for Whistleblowing, would you tell us about the improvements that you're seeking?
Well, thank you, Georgina, and thank you for your introduction. And it's really great to be on this panel today. talking about something which is so important to us, which is why I took over as the chair of the APPG just over a year ago. The all-party group was formed in 2018, in July 2018, for the purposes of looking again at the existing legislation and looking for ways that we could change it to really bring it up to the standard that we should expect now, which is perhaps not the same as the standard which it was expected in 1998 when our legislation was first brought in. So in order to do so, we want to ensure that the whistleblowers are properly protected, and part of that would be the introduction of an office of the whistleblower, which will look at things like setting standards to enforce protections for whistleblowers, acting as a point of contact for individuals who want to make a disclosure, ensuring that whistleblowing cases are investigated, and also working with those organisations and regulators to make sure that they ensure that whistleblowers are properly protected. We want whistleblowing to be defined in law, to include people who aren't just workers, because the scope at the moment is quite limited. To address the issues around retaliation against whistleblowers, and to make sure that that is addressed robustly. At present, the way that the law proceeds doesn't give all whistleblowers perhaps the protection that they would want to have and the recourse that they would want to have. We want to also look at the barriers of justice, the barriers to justice for whistleblowers, and that could be around the protections of legal aid, etc., that they have, and review the prescribed persons, which are the people who have a responsibility once they are informed of whistleblowing to take some action and to do something on their behalf. So I think really it's about looking at what we have and making sure that for the people that now are needing to have the protections that they want to have when they highlight wrongdoing or risk perceived wrongdoing, that make sure that those protections are in place, but also to give the confidence to people to come forward so that they can feel that they can blow the whistle, be listened to within their organisations, and if they are not listened to within their organisations, be listened to elsewhere. That's why we think the creation of an office for the whistleblower is really important.
Thank you so much, Mary. I'm going to come back to some of those points that you've raised, but I've got another question first that links into the issue you raised about consequences for those who blow the whistle. So, because there's really a day that goes by when whistleblowing is not in the headlines somewhere around the world. And we know from the experience of all of those who bravely speak out about the wrongdoing that has a catastrophic consequence for them and often the world around them. Lindsay, turning to you now, based on your experience in the financial sector covering whistleblowing cases and the regulators, what are your key observations about current protections and are they working?
Thanks for having me on the panel, Georgina. It would be a very short answer, but in a nutshell, no. Certainly not based on 4 years of covering employment tribunals and interactions with regulators around whistleblowing in financial services. And maybe if I just quickly take a step back, financial services is somewhat unique in the UK in that the regulator has very clear whistleblowing rules. It's rather jargonistically called SYCS 18, and there are supposed to be very, very serious consequences for mistreating somebody who has made whistleblowing allegations. In my 4 years of covering this area, I have not seen one instance financial services profession as a result of their mistreatment of a whistleblower. And so I'll just leave that there. And then if I could just give a bit of color with some of what I've observed in my time. So I've seen examples of internal investigations which have been signed off by, again, something is unique to the UK financial services world, the so-called whistleblowing champion, who is in each financial services company to protect whistleblowers and those making protected disclosures. So I've seen investigations signed off by the Whistleblowing Champion, which a year later have been declared wholly inadequate and tokenistic and flawed by an employment judge, and yet the bank concerned did not go back and revisit its decision that there was nothing wrong with its whistleblowing process. In another example, invariably somebody makes a whistleblowing disclosure and then all hell breaks loose and they end up before an employment tribunal if they are robust enough and fortunate enough to be able to take that avenue. And not everybody can. There are a lot of people whose mental health is irretrievably damaged by the whistleblowing process. Not by the process, by actually having made a disclosure. And the disclosures that I particularly am interested in and I cover are those that are actually regulatory breaches in and of themselves. So the individual has reported something to their employer, which is actually a serious regulatory breach, or maybe not even a serious regulatory breach, but it is a breach of regulation. And then it unravels for them in their employment. And so that's a pattern that you see time and time again, unfortunately. What do the regulators do? Well, in the UK, the Financial Services Authority supervisors never attend tribunals. There's no requirement on firms to notify a tribunal when they are, to notify the regulator when they are facing a tribunal under a whistleblowing allegation. Firms only have to notify the regulator of outcomes of tribunals if they lose them. And so I would say there's a body of evidence and patterns of behavior that the regulator is entirely ignorant of and oblivious to, because it never sits through the evidence in an employment tribunal. So it's not aware of this. And that's perhaps we've been charitable because myself and other journalists report on it, but that's a key thing. As Mary will know, because it was kindly mentioned at the reading of the bill, my reporting had highlighted that there are at least 1,000 whistleblowing reports made to the regulator itself, which are still being investigated. Some of those are 2 years old. So if you instead of going to your employer, if you raise it with the regulator, you're not actually getting any further down the line. So I know that sounds incredibly depressing, but I think making or lawmakers who sit above the regulators, holding the regulators to account for not using their own rules, such as when a tribunal is found that there's a judgment from a tribunal that says somebody has been dismissed for whistleblowing, why is that firm not held accountable, or individuals in that firm held accountable? The SYCS 18 is very clear that mistreatment of a whistleblower can actually lead to a breach of threshold condition 5, which is about as serious as it gets for a corporate entity. And yet this is never used, or it has not been used to date. So it's just, somebody to hold the regulators' feet to the fire, and then that knock-on effect of that down through the system, I think would really improve things. One final thing, the EU Whistleblowing Directive, I know it's not called that, but everyone calls it that. It has flipped the burden of proof. So where firms, where a whistleblower claims mistreatment, the burden is now going to be on the firm to prove that they did not mistreat. Something like that might be worth considering by UK lawmakers as well. Thank you.
Well, Thank you so much, Lindsay. You've raised a number of really important issues there, all of which have been receiving huge amounts of consideration by Mary Robinson and her team at the APPG. And I think I'd summarise what you're saying there by saying that the current legislation, the rules as they stand, across not only the financial services sector, but across all sectors, leave very little incentive for regulators to actually act on them at all, because it seems that nobody's really looking. I'm going to come back to some of the points you raised shortly, but I'm going to move on to Anthony, because this has a direct link, this about compliance and how rules and regulations are applied in the UK, and perhaps might explain why so many UK whistleblowers take themselves across to America and to other jurisdictions where they feel that they may be properly recognised, compensated or protected. But Anthony, you've got extensive experience of representing thousands of members of the public over many years, and you've dealt on their behalf with the police, the National Fraud Agency, Serious Fraud Office, Crime Agency, and others, not just here in the UK, but abroad as well. Now, thinking back over those challenges, the ones particularly supporting whistleblowers and their dealings with the regulators, what changes do we need to support whistleblowers across the financial service and other sectors? And what are you hoping for from the Office of the Whistleblower?
Well, I think one of the biggest problems is we have a revolving door between the perpetrators and the regulatory authorities. And this is very, very clear. And I think the best way to illustrate this is probably to mention the Sally Masterton case, because that is such a clear one. I mean, Thames Valley Police between 2014 and 2017 put a case together against a massive bank fraud in Halifax Bank of Scotland, which was perpetrated out of a Reading branch. It was a fraud of about getting on for £1 billion. They were only prosecuted on 245 million. Throughout that period when we were prosecuting it, the bank, I have to say, were less than helpful. It was Lloyds who'd taken over HBOS. But one of the documents that was actually found in that investigation was a very, very comprehensive report written by an internal forensic accountant within Lloyds called Sally Marston. It was a report called the Turnbull Report. It's about 165 pages. And it lays out in detail what was going on in the bank and with a number of companies. And it names the names and the individuals. And it lays out extensive fraud and corrupt practices that were going on within the bank. And we also discovered that the Financial Conduct Authority had had sat on this document and done absolutely precisely nothing about it. When it actually came out that we had the document, the first thing that happened was that Sally Marston was sacked by the bank, and sacked without proper compensation. And they then started to say, well, there were three main things they said. Let's just, sorry about that. They said about her.
Anthony,
yeah.
Just take, it's pre-recorded so we can take a break. Go back to where you were before the bing bings.
Yes. Lloyds Bank came up and said that a number of things about this report when they were actually asked about it. They said that, firstly, it was totally unsubstantiated. Well, everything I have seen, everybody else has seen, that it was totally substantiated. They said it was totally unauthorized by a rogue employee. Well, it was authorized because I've actually read the correspondence between the Lloyds head of audit and risk and Sally Marston discussing the report. So it was clearly authorized. And lastly, they said basically she was totally unreliable. Well, she was a highly respected, highly reliable accountant within the company. What was depressing was the FCA did nothing to protect her at all. The Financial Conduct Authority should have stepped in. They didn't. And it required a number of people, including yourself, Georgina, and others, to step in, and myself and Lord Hollick and others, to actually have the chairman of Lloyds in front of us. And eventually, after 5 years, we got her compensation, and properly compensated. And Lloyds had to admit what had gone on. But again, the Financial Conduct Authority should have done something about this. Eventually, Lloyds were fined.
Okay, let's...
Sorry.
Yeah.
Let's try and kill this telephone completely.
Bear with us, Damien. We're going to come back to this.
There we go. Sorry, it's because I arrived in such a hurry to this meeting.
That's
Okay.
If you can cut to the sort of what you think whistleblowers need and what this office needs to do, that would really help.
Right. Well, I will. I'll quickly just go back to the Lloyd's business. One of the problems, of course, was the Financial Conduct Authority was chaired by the late senior partner of KPMG, who'd audited the HBOS accounts, and they overlooked a huge hole in the accounts. And the PRA, which is meant to keep an eye on accountants, was chaired by an ex-chairman of Lloyd's. So again, you see the revolving door of the regulatory authorities means it's almost impossible for a whistleblower to actually whistleblow successfully today. Now, clearly we need protection for whistleblowers. And in this case, actually, if everybody had done their jobs properly in the Financial Conduct Authority, there would have been protection for her. But for most whistleblowers, there isn't something, it wouldn't be in front of the Financial Conduct Authority, and there is very, very little protection to them. In the very few cases where people are compensated, or when they leave their jobs, or they have to leave early because they've whistleblown, they are immediately stuck with an absolute draconian non-disclosure agreement, which again is a very frightening process of lawyers and everything. And we need some ombudsman in place, some position in place to whom whistleblowers can actually go and will defend them. Now, in America, they have that. We do not have that in this country. And if you are a successful whistleblower in America, you get very, very heavily compensated. In this country, you lose your job without compensation. That is the difference, and that is the difference that has to be sorted out. And at the moment, it is not being sorted out. And if you can get your act through Parliament and everything, we are at least a very long way to sorting this out. But it is a huge hole in our system. And of course, it means there is corruption and dishonesty that can go on without anybody doing anything about it. And if they do, they get sacked. And that is clearly wrong.
Well, I think you've raised so many really important points, including you've touched on some of those that were in the 10-point plan that Mary Robinson and her predecessor, Stephen Kerr, put together as part of the report that we jointly wrote for the All-Party Parliamentary Group in 2019. Is now, I know, being very busily worked upon and culminates in the establishment of the Office for the Whistleblower, which will address those issues about the regulators, the revolving doors, and being too close to those that you regulate, which so far seems to be very much the theme of what we're talking about here. And I know Mary's going to have a few more things to say in a minute, but first of all, Alexandra, you've been sat there very quietly, as you always do, listening. So I'm sure that you're going to have some really important messages for us to think about here. But we all know that taking legal action against any organisation who behaves badly towards whistleblowers is expensive, debilitating and time-consuming. It's really the ultimate David and Goliath situation. It's well written about, lots of people are writing books and films and so on, but for the person involved in it, it's incredibly personal. And more importantly, legal support in order to seek proper redress is beyond the reach of the majority of people purely because of the expense. So Alexandra, from your perspective, what needs to change in order that whistleblowers get the protection and the legal support that they need, and ultimately that the public gets justice?
Hi, Georgina, thank you very much. And how wonderful it is to have this very important conversation for National Whistleblower Day and our friends across the Atlantic who have dealt with whistleblowers in their regulations and in their laws a lot more than we have here on this part of the planet. And when I speak to friends in America, lawyers, and I tell them what our laws look like here and what protection is afforded, or rather isn't afforded, to our whistleblowers, jaws do often hit the floor, especially saying that someone who has blown the whistle has faced tremendous retaliation from their employer, is beaten, feels awful, has to look for a new job, also only has 3 months then to go to the employment tribunal and ask for some sort of protection, which only comes in the form of compensation. But if I take a step back and refer back to what Mary said to start this conversation today, and we see that the tenets of what we are talking about today is that what we need is support for the whistleblowers, proper protection for the whistleblowers, proper protection to extend beyond to what is protected now and who is protected, which is simply workers and people in employment. We need protection against retaliation, and we need to bring out the barriers to justice that we see now. And does the current legislation do that? I would say no. As Lindsay said, it's a very short answer, and that answer is a no. And I think an emerging theme is the lack of accountability that the current legislation has created. There is a lacuna between someone blowing the whistle to protect the public and making known a wrongdoing, to a complete silence of what happens in the meantime, and then the employment tribunal coming in and putting a plaster over a wound that just will not stop bleeding. And that is not a system that is fit for purpose. And as Mary said, perhaps PIDA, when it was introduced, was fit for purpose then, but having seen it in action time and time again, it simply isn't fit for purpose today. Because I think what we have forgotten is, where did we start? We started with protecting the whistleblowers so that we can protect society, which is whistleblowing is vital for the protection. And as you said, Georgina, it uncovers corruption. It just simply doesn't do that. Why? Because we are missing the very important part of investigation and holding the wrongdoer accountable in one way, shape, or form. In there comes, of course, the debate about the regulators, which everyone on this panel has discussed, and I will not bore our viewers further with that. But is it fit for purpose, and is the support that the whistleblowers need there? Simply, there isn't. What we do not have in this country is a mechanism to hold the whistleblower's hand and show them what to do, how to do it properly to make sure that they are protected, and what they can do so that they can get their concerns addressed, which is why we see a lot of our whistleblowers actually going abroad, going to the States to blow the whistle, because there's a mechanism in place there where they will hold the whistleblower's hand. And if wrongdoing is actually uncovered, they will be compensated for that. Here, you report a wrongdoing, and then you're looking for a job, and you're most likely going to be blacklisted because no one will want to hire you if it's made known that you have blown the whistle, especially in areas such as financial regulation, healthcare, and education. So what do we need in place? We need the Office for the Whistleblower is what we need. We need more accountability, and we need to be able to provide people with the support that they need. And that includes bringing down the barriers to justice, including financial support available and emotional support available to them.
Thank you very much, Alexandra. You've raised a number of really important points here about not only the ambitions of the Office for the Whistleblower, but the work that Whistleblowers UK is doing to provide additional help and support to whistleblowers, not just in the UK, but all around the world. We do not discriminate. We'll support anybody. But you're right, the ambition behind the bill that Mary Robinson and her team are pushing forward with is all about protecting the whistleblowers and ensuring that the wrongdoing is investigated and action is taken against those who have been involved in that wrongdoing. But I know she's going to tell us more about that, because I've got another question that I'm going to start again with Mary, but ask you to each give me perhaps 1 or 2 sentences maximum about to answer or to consider on the back of the fact that some of the most significant crimes that employees have blown the whistle on in organisations, it includes those employees who often work across international borders, or they're not necessarily citizens of the country in which they're blowing the whistle. What message do you have for our international colleagues about how legislators, law enforcement and legislation needs to work more closely together to be successful? Mary.
Thank you, Georgina, and it's an excellent question. And Alexandra, I so agree with so many of the points that you've made there. And I suppose this is down to looking at the societal benefits and the business benefits of whistleblowers, and how if they are valued, it works for everybody. And we live in a world which it's a global world now. Since our legislation was introduced in 1998, the world has changed enormously. And so we know that the interconnections which were not there 30 years ago are very much present now. And I would say that that's where we have to make sure that the laws that we introduce, so hopefully the office of the whistleblower, that legislation is fit for purpose. So because legislation on its own does not solve the problem, it only works if it's fit for purpose. And I would like to see us working in a more global international way to ensure that we have a system which can be relied upon globally around the world. Because what does it say about us that a person who wants to whistleblow from the UK would seek to go to the US to do so, because the jurisdiction there will be more beneficial to them and actually will allow them to do so. And I thought that the mechanism to hold the whistleblower's hand is exactly what we need to have here. And it would be, I think, a real win for us if that was the top line of all of our whistleblowing legislation, not only in the UK, but across the world.
Thank you very much, Mary. Go a different way around this time, I guess. I'm going to come to you, Anthony.
Yes.
I was asking the question about how do we overcome the issues that arise with the position of international borders, because so many of our whistleblowers are international or.
I think
sorry, let me start again. You weren't ready, nor was I.
Yeah.
Apologies, Damien. So, Anthony, I'm going to come to you with the same question. And I'd like to have your thoughts on how do we overcome the issues that are presented by international barriers? What messages, especially with your experience, do you have for our international colleagues, law enforcers and legislators, for what they need to do to make things more effective?
Well, I think in those countries where they have thought about this, like America, the options are open to you. I think the problem comes in another country like the UK, where the options simply are not open to you. We don't have anybody to stand up for you. And of course, it becomes doubly complicated if a company headquarters is in one country, the whistleblower is in another. And very often that country won't be America, it'll be France or Germany or the Far East or somewhere. So, and there is no sort of proper international legislation, I don't think, on this. I think really you should be able to pursue it safely in wherever the company headquarters is, and that's where you should go. But as I said, if your company headquarters is in the United Kingdom at the moment, you don't get much joy. If it was an American bank doing this in the United Kingdom, I'm sure you would be able to successfully pursue it in America, and you'd have the support to do it and the compensation. But if you go against a British company in this country, you don't have the legislation or the system to support you. And of course, if you're a citizen working abroad in any country, really, unless that country has the legislation, you will not be looked after. I mean, what about somebody who's working, a German working in Hong Kong for a British company or something like that? It becomes very, very complicated at this stage. And I think really it's up to countries each to have their own act together. And what I hope we will get in this country is a system that, at least in this country, we have got the act together. That will take out a very large proportion of the whistleblowers will then have protection.
Yeah.
But I don't think we get. other countries to legislate necessarily.
So what you're really saying there is that what we need is a global solution to what really is a global problem, where we're all joined up much more completely as we are with the internet, and that we harmonise our legislation.
Well, it'd be very nice if we could, yes.
Certainly, that's the ambition I would like to be championing. I'm going to turn back to Lindsay. The same question. What message do you have for our international colleagues? I know that you work internationally already, in order to help address these really serious issues that often deter people from whistleblowing.
Thinking again about the sector I cover, financial services. I mean, 2008 gave us a very, very hard lesson, which many countries are still recovering from, into the interconnectedness of financial systems from one country to another. And so you would hope that should have resonated with regulators in their treatment and sharing of disclosures about the soundness and of various financial institutions and their practices, and the threat that could represent across borders in a similar way to 2008 again. So I guess, am I allowed to mention the Brexit word? I know it's not, but my point is, post-Brexit, what we have seen in the UK is the Treasury signing a number of cooperation agreements with different countries. So we have one with the US, just last week we had one signed with Singapore. And in the nitty-gritty of these agreements, there is cooperation and a setting up of a sharing of information between our regulators. And so you would hope that that structure would be used between regulators to share where they have information that something is not right across borders or affects more than one country. And I shall stop there.
That's a really interesting point. So what you're really saying is Brexit is actually an opportunity for us to fix some of these problems and ensure that going forward agreements include anti-retaliation and other protections for whistleblowers. Thank you so much. Alexandra, if you can still remember the question.
I can certainly try to, Georgina. I think I agree a lot with what Mary said at the beginning. We now have the systems in place to be able to share a lot of the knowledge that comes to the surface with dealing with these claims, dealing with whistleblowers and how the system works. And I think we need to start from a lot more information and knowledge sharing of what works and what doesn't work, and keep what works and bin what doesn't. And we can look at our friends across the Atlantic a lot and take a lot of examples of what they have done and how it has worked there. And that is not a particularly difficult thing to do, she says, knowing that the red tape involved is probably extremely long and never ending. But I think if we start there and then perhaps strive for a streamlined process of, if someone has gone to a particular jurisdiction to blow the whistle or seek some protection, then there is some process back home to protect, provide supports, and provide some help, because it's all well and good to have the ability to go abroad, let's say, and whistleblow, but what happens at home? Who is giving you that support there? So I think sharing of knowledge and streamlining would be my two keywords, perhaps, for your question.
Thank you. That was really helpful and very brief. But I like this idea about everyone coming together to talk and think more closely and collaboratively about how we share information and how we improve our international cooperation more widely to prevent, as I said at the beginning, crime, corruption and cover-up, and protect those who speak out. Now, as we draw this to a close, Mary's spoken at the beginning about effective frameworks for whistleblowing and supporting those who speak up to stop wrongdoing in its tracks, amongst other things, and also talking about how the law needs to be better understood. We've covered the idea that the thoughts about various ideas that could protect whistleblowers by preventing revolving doors. But I want you to just give me a little bit of thought, or what your thoughts might be on the future. For me, I think from the time that I spent on this whistleblowing journey and into helping to drive legislative change, I'd say that the future looks much brighter for whistleblowers. Anthony, would you agree? Very quickly.
Yes, I think it probably is now, but you're going to get a tremendous pushback from the establishment and the banks against getting this legislation through, I think. And it'd be very interesting to see who comes out of the woodwork to speak against it. And I think you will find the major perpetrators are going to be the loudest voices.
Thank you, Anthony. I think you can safely say that Mary Robinson's going to have a much louder voice than them, but I'll come to you, Alexandra, on that one.
I certainly hope so, Georgina. Unfortunately, through work, I see the picture when things have gone very, very horribly wrong already. So I certainly do hope that the future looks brighter, only to protect people who want to blow the whistle and uncover some wrongdoing.
Thanks very much, Alexandra, and thank you for all the work you do with whistleblowers coming to Whistleblowers UK. Lindsay.
Yes, so am I encouraged? It depends which way I look. So if I look at the passage of the Financial Services Bill through Parliament recently, the number of lawmakers, Mary and her colleagues, who spoke about the need to protect whistleblowers during the passage of that piece of legislation was really quite encouraging. It was cross-party. It was well evidenced, well thought through. And so if I look that way, then yes, I am encouraged that the lawmaker will right the ship or help right the ship. If I look to the most recent tribunals that I've no, and sadly, I'm not encouraged at all. The complete absence of a regulatory presence at any of those hearings, the patterns of, and it is patterns, the patterns of mistreatment that individuals have suffered. So no, so I'm not encouraged that way, but I want to be positive, and so we have this piece of legislation being discussed now in the UK, and I really hope it makes it through, because I think it will make a difference.
Thank you very much, Lindsay. Your insight from a very interesting and unique perspective really helps us to think about how change needs to be brought forward and what will work and what won't in a practical way. Thank you. I'm going to come to Mary for your sort of final thoughts and a final word on this, and make your pitch.
Thank you, Georgina. And can I just say thank you to you, Georgina, to Lindsay and Alexandra, because you're very much at the coalface of this issue. And as legislators, we are listening to everything that you have to say, acknowledging the work that you're doing, but seeing the problem and seeing a problem that we need to address and we need to fix. So when I listen to what's still happening, it could be the case that you would feel not optimistic and feel quite pessimistic about it. But knowing that there are so many people who want change, I think is a first point that I would make to say that we may get that change. And I'm hoping so. But on National Whistleblowers Day, I think it's important to reflect on the way that we share information now. It is key to helping whistleblowers to acknowledge that they can tap into information, they can access information themselves, that they can get the exposure that they need, and we have to ensure that they do that and get the knowledge and the confidence in the system as well. And it causes me to reflect on the fact that in 1998, when the Public Interest Disclosure Act was introduced, only something like 9% of the UK population had any sort of broadband at all. Google was founded in 1998, so people actually were only just seeing that they could get information from elsewhere. So we've got a much more connected world now, and I think that it is, and it's very interesting to hear the reflections about trade and how we can use that and how for opportunities to improve the rights of whistleblowers and the way that we help whistleblowers. And so I think that we have an opportunity because the light, if you like, has been shone on this subject. And I think as people get the confidence to know that there is something called a whistleblower, that they may be, and that they may see it as something positive and with a societal and a business benefit, when we can do that and tell them with confidence that they will not be suffering any detriment as a result of it, then I think we will really benefit the entire society, both in the UK and globally.
Thank you so much, Mary. And I'm really mindful of time, so I feel like I ought to wind up now by thanking all of our panelists, Mary, Anthony, Alexandra, Lindsay. And I'd like to take the opportunity to thank all of the team at Whistleblowers UK and our friends and colleagues at the National Whistleblowing Centre over in Washington who have put on this day, and also thank everyone who's listening to this across the whistleblower community and the wider communities. And we hope that you recognise the hard work that's being done in the UK, not just on this day, but every day of the year. Now, there's a couple of other messages I suppose I want to say. Apart from listening to what we're doing here in the UK, we're certainly bringing things on in leaps and bounds. There can be no doubt that the proposals that I'm so proud to be part of, that Mary is leading, will create a safety net for all citizens, not just here in the UK, but across the rest of the world. And we hope that the standards that we are seeking to set are gold standards that again lead the way, like PEDA did back in 1998, and that we'll be going to go back to normalising speaking up, because it's something that we all do. And in doing so, get more introduced to the way that technology can help us in that. Let's not be shy for everything that's out there. Let's help people to speak up safely and ensure that, more importantly, the wrongdoing that they're identifying or alerting us to is dealt with by people like Anthony Stansfeld in his crime fighting role that he's had. So on that note, if anyone has got any further questions or wants to contact us, I hope that our email address will be made available to everybody. And please, if you want to get involved with us, drop a line. And in the meantime, again, congratulations on yet another successful Whistleblowing Day, both America and around the world.